Welcome to the People's Law School. My name is John Brinkley, and I'm a trial lawyer and a member of the Alabama Association for Justice. I'd like to thank Mayor Tommy Battle for allowing us the opportunity to be here in the city courtroom, along with the city judges, Judge Sonny Rodenhauser and Judge Sybil Cleveland. We've been given the opportunity to be here through the gracious efforts of the city of Huntsville, and for that we are thankful. It is my pleasure to get to introduce a friend of mine named Lee Nation. Lee handles Social Security claims, which you're going to hear a lot about here tonight. I will tell you that what I learned from Lee here recently, I taught a continuing education sometime last year, and Lee followed up after I did, and I will tell you that I learned a lot more about Social Security, and he made it sound so much easier than I would have ever explained it. So y'all are in for a real treat. A little bit about Lee. He's born and reared here in Alabama, went to school in Tuscaloosa. His dad is a judge in Walker County. He graduated from the Thomas School of Law. He's got a brother who's also an attorney, and his wife is an attorney, and she's seated here with us tonight with their son Jimmy, who will be here soon. So welcome, Jimmy. We have and I will tell you this about his wife who's seated here in the front. She's a lawyer, and I promise you she's smarter than me and Lee. So hats off to Amy, and good work, Lee. He's a member of NOSCR, which is the National Organization of Social Security Claimants Representatives, and also a member of the American Association of Justice. Recently, Lee was elected to our local Huntsville-Madison County Bar Association as the secretary, which is to say that he takes the minutes and he helps participate in what we decide to serve for lunch. And that's a very important thing when you're trying to feed about 100 lawyers first Wednesday of every month. Something interesting about Lee that's non-legal related, he's a beekeeper. And I think that's really kind of neat. You've seen that in the news here lately. And he does have a colony. There have been some cold snaps that have hurt his beekeeping process, but he may get into that here after the session is done. Please welcome Lee Nation. He's going to talk to us about Social Security.
Thank you. Thanks, John. John has been a good friend for many years, and he's an excellent attorney. And I'm just happy to be speaking to you all tonight, and hopefully I can be as informative as I can be. Before I get into the nuts and bolts of Social Security, I'm going to talk about a brief history of Social Security and really pensions in general. In fact, pensions help protect American workers. The first pension was in existence prior to the signing of the Declaration of Independence. That pension went to help soldiers who were injured during the Revolutionary War. After Revolutionary War, into the Civil War, in 1867, the state of Alabama started paying pensions to Confederate soldiers. In fact, the federal government started making those payments as well, and by 1910, over 90% of the remaining Civil War veterans were receiving a Civil War pension. Interesting fact there is that in 2012, there were still 2 people receiving that Civil War pension. They were the children of 2 federal soldiers. So I don't quite know how that happened, but that's an interesting fact I came across. Following the stock market crash in 1929, wages paid to workers decreased from $50 billion to $30 billion in 1932. FDR signed the Social Security Act in place on August 14th, 1935. Now, the reason I talk about a pension is Social Security is kind of like a pension, at least the main disability insurance benefits program that we'll talk about. Workers pay into payroll tax throughout their time that they're working up to 10 years, and then they become eligible for Social Security. So in that way, I believe that Social Security is kind of like a pension that's there in case they need it in the future. The Social Security Act was amended in 1954, and that created the Disability Insurance Benefits Program, the program that is the main program today for Social Security disability. And in the 70s, the Act was amended once more to add supplemental security income program, which helps what is defined as or helps what is called a needy disabled individual. So Social Security today, there's nearly 12 million people who are receiving Social Security benefits today, disability benefits. And you see it in the news why there's so many people receiving these benefits. And a few of the explanations I saw that seemed to make sense to me were, the amount of baby boomers that we have right now. People are twice as likely to become disabled at age 50 as they are at age 40, and twice as likely to become disabled at age 60 as they are at age 50. And when you have that many people, age between 50 and 60, there's a lot of people on disability, just to the sheer number of potential workers at that age. Also, the retirement age. When you start receiving Social Security disability, you remain on this program until you reach your full retirement age. And as Social Security increases this full retirement age, that means that the Social Security Disability Trust has to pay for these disabled individuals past 65 up to 67 and 70 in the future when it goes up again. But just few workers have alternatives. Only 1 out of 3 private sector workers have private long-term disability insurance. It's a situation where a lot of people, if they get injured at work, they have nowhere to turn. They have no long-term disability benefits, no short-term disability benefits provided. This is all they have. Now, there's 2 main types of Social Security. There's what's called DIB, disability insurance benefits, and then there's SSI, supplemental security income. Now, DIB is funded through workers' payroll deductions while they're working. And in order to qualify for this program, you have to have worked 20 out of the last 40 work credits. So that's 5 out of the last 10 years. If you don't have that under your belt, you can't qualify for the program. The average disability insurance benefit is $1,100 a month. Now, for the average person, these monthly benefits equal less than half of their income before they stopped working. So it's a very modest benefit. There's no income requirements or limits for eligibility. I've represented rocket scientists that have hundreds of thousands of dollars worth of pension, and they're still eligible for this program. Like I said earlier, if you're still receiving Social Security disability when you reach your full retirement age, the program will just simply shift, and the Social Security Retirement Trust will start paying your benefits for you when you reach that full retirement age. Now, the other program we talked about is SSI. Now, SSI doesn't focus on payroll contributions. There's no requirement for working 20 out of the last 40 credits, 5 out of the last 10 years. The program is a needs-based program, and it's based on income. So generally speaking, you have to be within 200% of the federal poverty level to qualify for financial eligibility under this program. As far as medical determination, both programs are the same, exactly the same process to determine whether or not someone's disabled. The maximum SSI benefit in 2016 is $733 per month. And what we'll see is the average payment will be somewhere around $500, because if you're someone who qualifies for SSI, meaning you're within that 200% of the federal poverty line, there's going to be people helping you out, and Social Security will deduct any help and assistance you receive from some other person from the amount of benefits you're receiving. So, in effect, your average SSI claimant is earning somewhere around $500 per month. A couple other programs that I'll just mention, but aren't the main cases that you see often. There's child SSI cases. children whose parents qualify financially for SSI, and these children, since they haven't worked, it's hard to compare them the way that adults are treated in the disability program, but a child, if they don't automatically meet a listing for some certain disabling condition that Social Security has agreed that is a disabling condition, then that child is compared to their peers to see how they perform versus their peers, if they have to take more time out of class, how much school they're missing, things of that nature. The other program is widow or widowers benefits, and that program allows widows or widowers to become eligible for Social Security based on their spouse's, their deceased spouse's work history. And and you have to be at least 50 really to get those benefits. But how does someone apply for Social Security disability? Well, first you have to ask the question, do you have a illness, injury, or condition that keeps you or will keep you from working for at least 12 months or is expected to end in death? If you are still earning more than, I believe the number is $1,130 this year, you're ineligible to apply for Social Security while you're still working. But if you're earning less than this $1,130, you still qualify. So part-time workers can still apply for Social Security disability, even though they're still earning a small wage. Once you have applied, you're also encouraged to go back to work from Social Security through programs like the Trial Work Program. And this program does not punish any claimant who tries to return to work and is unsuccessful within 90 days. So if you go back to work and for some reason you can't work due to your condition, Social Security is going to say you're still eligible to continue with the disability process, which is so long. This is important because most people don't have any income for somewhere around 12 to 18 months during the application process. You can go to your local Social Security office to make an application, or you can make your application online if you're applying for disability insurance benefits. And when you're making this disability insurance benefits application, they'll ask you questions like current marriage information, when you were married, who your spouse is, to make sure you're not eligible for any benefits under your spouse. They'll ask about prior marriages, names of your children. Social Security will pay an auxiliary check to any disabled individual's family above and beyond the normal disability insurance check. And this helps feed children in the house who's lost a breadwinner due to an injury. And the amount they receive, I believe, is a little bit less than 1/5 of the amount that the adult would receive. Social Security will ask about which doctors you've seen. They'll ask about work history in the last 15 years. Social Security believes that the only relevant work history is work history going back 15 years because skills learned prior you'll kind of forget about, or the job may have changed in the last 15 years to really make it irrelevant. It helps to write this information down before filling out the application. If you're completing the SSI application or this DIB application, it may be difficult to just recall offhand the last jobs you had over the last 15 years, but the Social Security office is here to help. They do a good job with the number of people that have applied for disability in our region, which is very high. And they're also doing a good job due to the short staffing that they have and the low budget they have, and their hours of operation have also been cut substantially. I believe they're only open for 2 hours on Wednesday. So if you ever need to go to the Social Security office, do not go on Wednesday. Depending on where you are in the area, there's different field offices where you can go in and make these applications. Social Security doesn't always tell you their field offices' addresses or phone numbers. So if you ever need to go to the Social Security office and you're not sure where your Social Security office is, you just go to ssa.gov and you type in office locator, and this will pull up a search by your zip code that will direct you to your nearest field office. So once your application is filed, your local Social Security office sends your case to Disability Determination Services in Birmingham, if you're an Alabama resident, and they send it to Department of Human Services in Nashville, Tennessee, if you're a Tennessee resident. Here you'll be assigned a disability examiner, and this person's job is to develop the record, order medical records for you, possibly refer you to a physician for a brief examination if they believe that's needed. And then they will bombard you with paperwork. The average applicant receives 2 or 3, roughly 10 to 12 page packets that must be filled out within a week or 2 of receiving it. There's also in these in this DDS office is what it's referred to, this Disability Determination Services office. There are doctors there who examine the medical records and the case file to see if they can make a favorable decision. Now, these doctors never meet the claimant applying for disability. They never see him. They're just basing their decision off of medical records in the file and that brief examination made by a doctor, if that happened in that case. Attorneys can be helpful in this initial application process, though not all will help you in the initial application process. But personally, I like to get my cases as early as I can get them, not trying to conceal anything, or it's just I know what is relevant to Social Security. I know how to draft these interrogatories to treating doctors and ask them the right question that I know that a judge is looking for. There's also, if you're having problems getting into a doctor, there's several low-cost treatment options that are available that an attorney is going to be able to guide you to. And that's important because not all free clinics will accept a patient if they're applying for disability. So that's actually, if they find out, a lot of them will just kick them out of the clinic. So finding health care options can be difficult for someone without health insurance and who aren't able to avail themselves to the free health clinic. Now, if you receive a denial after this panel of doctors and after this disability examiner has ordered your medical records and gathered all your forms, if they deny your claim, then you only have 60 days to file a request for hearing. And that's in Alabama, because Alabama is a prototype state, meaning we don't have this extra stage that everyone else has. If you're living in Tennessee or most every other state, you would file for what's called reconsideration. But Alabama is, back in, I believe it was around 99, we'll try out this new process of skipping the reconsideration phase and going straight to a hearing. I personally like it because I like getting my cases in front of administrative law judges. I feel like the claim gets examined usually much more closely than it does at the reconsideration phase. But so in Alabama, you file a request for a hearing. In Tennessee, you must file for reconsideration first, and then if you're denied, then you must file for your request for hearing. And 60 days is the time limit for appeal that Social Security uses when you receive a denial. Once your request for hearing is filed, your case then leaves the Disability Determination Service and goes to an office called the Office of Disability Adjudication and Review. You can see why Social Security uses all these acronyms. It's tough for someone who uses these words all the time to even spit them out, but that's called ODAR. ODAR will keep jurisdiction of this case all the way through your hearing with the judge. ODAR is where these Social Security judges are located. Once you file your request for a hearing and you get in this phase, Social Security pretty much goes, radio silent. You no longer receive any phone calls. You get one letter that's called a 20-day letter. And it's called a 20-day letter because it says, we will give you 20 days notice prior to a hearing being scheduled. So whenever that letter is sent out, attorneys joke that's when their clients call and say, I have a hearing in 20 days. So that's how it got its name, the 20-day letter. Social Security also will send a form asking if you have any objections to a video hearing. Right now, I believe in Florence, that's the ODAR office for most of North Alabama, I believe like 95% or close to it, 95% of hearings are in-person hearings, and there's only 5% that are video hearings. But I usually tell my clients that we want the quickest hearing. We don't care if it's a video or in-person. We just want the quickest hearing. And that's because the average wait time for a hearing from the time you receive your initial denial until you can get a hearing is 486 days in this area. And Social Security has done a good job to lower it to 486 days. It's gotten much higher than that at times. The Birmingham ODAR office is 516 days, 569 days in Chattanooga, 509 days in Franklin, Tennessee. So Franklin, Tennessee, if you're on that 65 corridor, Morgan County, going towards Tennessee, they send these folks to the Decatur field office, and the Decatur field office then has all of their judges in Franklin, Tennessee. So most of North Alabama is Florence, but then there's this little area down the 65 corridor where everyone's going to Tennessee for a hearing. After your hearing, and we'll talk about your hearing and the details in a minute, but after your hearing, you'll receive if you're going to receive a fully favorable decision, it will be usually within a month or a month and a half. And it's a little bit quicker than your unfavorable decisions because they're a lot shorter if they are fully favorable. If you receive an unfavorable decision, that can take 3 or 4 months after your hearing even occurred. And it's very important not to kind of stick your head in the sand at that point if you receive an unfavorable decision, because you still only have 60 days to file your next appeal. Now, while your greatest chance of being found disabled statistically occurs at the administrative law judge level, at the hearing level, there's still different appeals that you can take from there if you're denied. If you filed an appeal of an unfavorable decision, the case would go to the Appeals Council, which is located in Falls Church, Virginia. It's kind of a mystery how they review cases, but it can take up to a year for an unfavorable decision to be reviewed at this level. And if they agree with you that there's a merit to your appeal, that the judge was in error, or that there was newly discovered evidence, the most common thing they do is send you back to your local hearing office for another follow-up hearing. But that happens minority of the time. Majority of the time they deny any further review, and then that again triggers a 60-day window that you have to file a lawsuit in federal district court. It's tough there's not a lot of lawyers who actually handle these Social Security cases at the federal district court level. So if that is a situation you find yourself in, I'd recommend calling the Alabama State Bar Lawyer Referral Service. Their phone number is 1-800-392-5660. You may be able to find a list of attorneys that would represent you in federal court. In federal court, you wouldn't get a new hearing necessarily. They're just going to review the evidence that's already in the file to see if it was based on substantial evidence or if there was a error of law. But getting back to that hearing, the greatest likelihood you have of winning at any level in Social Security. This hearing isn't like any other court hearings that you will see on TV or have really ever seen anywhere. It is a kind of a small conference room you're sitting in, and there's only 3 people in there with you. There's no place for anyone to watch, anything like that. It's a tiny conference room in Huntsville. It's on the corner of Clinton Street and Church Street in this little office building. You would never know it was there. But who's in this hearing? There's the judge, administrative law judge. There's your court reporter, you, the claimant, and the claimant's attorney if they have one. And any claimant's witnesses usually sit outside until they're needed. Also in that room from time to time is what's called a vocational expert. This is a person who is whose job is to tell the judge and provide advice as to how many jobs are available in the national economy that the claimant could work with their different disability conditions or illnesses. There's no attorney representing the Social Security Administration at this point, so it's a non-adversarial hearing. But there's been some talk about adding an attorney general to start coming to these hearings to represent Social Security or the taxpayer. And I mentioned a vocational expert, and there's also someone called a medical expert that, in my experience, has only been in about 5% of my hearings. And they're a doctor, and they give an opinion whether or not someone's medical conditions would automatically qualify them to be found disabled. And if the judge also has any questions, they can ask this medical expert questions about any medical conditions. Like I said, where's the hearing? In Madison and Limestone County, you're going to a little office on Church and Clinton Street, or you're going to Coleman, or you're going to Florence. It's just whichever you can get into first. Morgan County cases go to Decatur or Franklin, Tennessee. Marshall County cases go to Gadsden or Birmingham. The recent statistics show that there were 282 hearings in the Florence hearing office from September 25th last year to October 30th. So just over 35 days they held 282 hearings. And still this backlog is around 14 months or so. Why do we have the hearing? It gives an opportunity for the claimant to ask any questions to any witness, or the attorney to ask questions to the claimant to have their day in court and explain why they believe they can't work. Like I said, it's a very laid-back proceeding. You're either going to be speaking to a judge on the television or in person, but most of the time it's in person. And it's very rare for witnesses to be called in these hearings. At least I don't usually call witnesses unless my client is unable to express themselves well, which can occur in certain mental illness cases. But how is someone found disabled? Social Security has, in the Social Security Act, they have this long definition and they define disability as the inability to engage in any substantial gainful activity, and can be expected, the condition can be expected to last for at least 12 months. So what is substantial gainful activity? In 2016, with the cost of living adjustment from previous years, it's $1,130 is considered gainful activity. So if you're earning $1,130, you do not qualify to apply for Social Security disability. I'm sorry. Per month. Per month. Work can be considered substantial even if it's on the part-time basis, where I've had cases where someone didn't quite earn $1,130 a month, but they earn up there towards it, and Social Security has said, we believe that you should be paid a wage that would put you above the $1,130. So we find that you are working at a substantial gainful activity level. But if Social Security decides that you are not earning money at a substantial gainful activity level, the next question is does the claimant have a severe impairment? Now, an impairment is not severe if it does not significantly limit their ability to do basic work activities. And basic work activities are walking, standing, sitting, using hands, reaching, carrying, speaking, hearing, using your judgment, using concentration, being able to stay on task during the workday. Now, you'll see frequently people's, some of the most common conditions I see are back pain, low back pain, arthritis, depression, anxiety. All of these conditions can cause different effects on a person that really may, back pain is going to keep you from being able to concentrate. And Social Security says that if you're unable to concentrate for at least 2 hours during an 8-hour workday, then there's no job for you. So a lot of conditions that cause pain, that's really what we're looking for to see, to try to develop a theory for this person to be found disabled. If there's issues, I mentioned arthritis. Sometimes people with arthritis that's severe enough have a problem getting out of bed in the mornings, and that causes absenteeism. If a person misses at least 2 days of work in a month, Social Security says there's no jobs out there for that type of absenteeism. When someone claims they're in pain, their statements alone are not sufficient for Social Security to make their determination based on just saying, my back hurts. They want to see medical signs and laboratory findings. They want to see, if you're claiming back pain, have you had a back surgery? Have you seen an orthopedic doctor? Have you tried to take care of this condition? Or are you just saying I have back pain and you can't really disprove that I have it? Social Security is really tough on pain cases now. They want to see medical signs that can show that this pain could reasonably be expected to be occurring in a person. Once Social Security decides that a person has a severe impairment, the next question is asked is whether or not they meet the listings. Social Security has a blue book that contains the most common disabling conditions in it. For example, there's a listing, 12.05 is for intellectual disability. So if a person has an IQ of 59 or less, they're automatically found disabled. If a person has an IQ between 60 and 70, and they have any other severe impairment at all, then they're found disabled. So this kind of, gets right to the chase and cuts right to the chase and helps make quick determinations in these hearings if these certain conditions are met. If a claimant does not meet a listing, which most people do not, Social Security asks whether or not that person can do past relevant work or work that was done in the last 15 years. And they classify your past work into different, what they call residual functional capacities. There's sedentary work, which is office work carrying up to 10 pounds at a time. There's light work that is lifting no more than 20 pounds at a time. And there's medium work's 50 pounds, heavy work's 100 pounds. And each one of these classifications are used to determine, whether or not someone who, may not be able to lift 100 pounds anymore might still be able to go work in an office and, pick up files. So at this step, the judge considers whether or not the daily activities may be seen as inconsistent with the presence or condition that would preclude all work activity. So they're just really looking to see how a person can take care of their personal needs, prepare easy meals, do light housework. These questions that are asked in these forums early on are used to determine how much work you can do and what classification of work. If Social Security finds that a person cannot do the work they've done over the last 15 years, the question then becomes, is there any job available for this person? And that's where that vocational expert who's sitting in the hearing can help state whether or not there's jobs in significant numbers in the national economy. So, if I used to work construction for 20 years, doing medium work, can no longer stand 6 out of 8 hours a day. This vocational expert may be able to tell me, based on my education, would there be any sedentary jobs available in the region? And they can, they state the number of jobs available in your state, and they also say nationally. So they may say, well, there's 200,000 secretary jobs available across the nation, and 20,000 of those jobs are available in North Alabama. So they're there to help provide information to the judge to let you know whether or not there's jobs that a person could do based on the limits of their ability to stand or sit or walk or lift. The way Social Security is structured, the older you are, the easier it is to be found disabled. Social Security believes that a person older than 50 will have a more difficult time learning a completely new job in a new industry than a 20-year-old would. So these factors of being able to transition into different types of work, the construction worker trying to transition into a secretarial job may not be able to make that adjustment if it's been 30 years since the last time they went to school, or if they had no typing experience or computer training. But the older you are, if you're over 55, for Social Security purposes, you're considered a person of advanced age. So once you get to 55, it gets easier, and that's their words, not mine, as to advanced age. Frequently asked questions. People ask, do I need a lawyer? There's a study that I saw a few months ago that said that a person who had legal representation in a Social Security hearing has a 24% chance, has a higher chance by 24% of being found disabled. So you can represent yourself in a hearing. You can have a family member represent yourself in a hearing. But I believe that it would benefit you if you did have an attorney represent you in the hearing. Another common issue we see is, would substance abuse affect someone's claim for disability? And the short answer is that if the condition would still be in existence even if the substance abuse problem did not exist, then Social Security ignores the substance abuse issue and makes a determination of whether or not that person's disabled. So if I have, if I have cancer of some kind and chemotherapy keeps me from going to work, but I also have a alcohol abuse problem, Social Security will look and say, well, does the alcohol abuse, is that what's causing this cancer? And if they say it is not, then they kind of ignore the alcohol abuse problem and make the determination on whether or not the cancer is actually disabling. Can someone get disability if they've been convicted of a crime? If you are, while you're in prison after being convicted for a felony, you're unable to be to receive any sort of disability benefit. If you were injured while during the commission of a crime, you're ineligible to receive disability for that impairment. If you were injured in prison, and that's your basis for disability, you're ineligible to make that claim. So for those particular instances, someone that's currently in prison cannot receive benefits, but if they got out and their condition wasn't caused by anything during the commission of the crime or while they were in prison, then they would be eligible for disability once they got out of prison. How is Social Security different from workers' comp or long-term disability insurance? You know, I get asked a lot. So let me tell you about my long-term disability problem. Long-term disability is pretty much an insurance contract that you have. It provides benefits for you in case you become disabled. You pay a premium every month for it. That's something that's totally different from Social Security, which is a system run through the government. However, there's a potential for, if you have that long-term disability contract, that benefit, and you're receiving that benefit, your long-term disability provider may try to claim that any money you receive for Social Security should go to them. So it's very important when you sign a long-term disability insurance contract agreement for insurance, you read it and see what that long-term disability provider wants from you if you were to be found disabled under Social Security's rules. And a lot of times these long-term disability providers actually have in their paperwork that you must apply for Social Security disability or you lose your long-term disability benefits after a certain period of time. So they may say, once we start paying you long-term disability, you have 6 months to apply for Social Security, and if you don't, we may cut you off. And also, if you win, we get a large portion of it. Yes, Mr. Brinkley.
Lee, a minute ago you referred to the guy who has cancer and is also an alcoholic. Would you comment on the hydrocodone, the Loratab, and the back injury fellow? That seems to be what I see the most of.
Right. Well, if you alcohol abuse or drug abuse, if this back injury, if you have a worker who injured their back on the job and they need a surgery, but they also have a substance abuse problem, if that back condition's still going to be there, even if they stopped using drugs, then Social Security ignores it. But that is the only time during a hearing that the burden of proof is on the claimant. The rest of the time, the government must prove that someone is not disabled. But dealing with substance abuse issues, the claimant must prove that they would still be disabled even if they didn't have these issues.
What are your fees and how do you get paid?
Congress sets what an attorney that handles these cases can charge, and it's everyone I know charges 25% of the back pay. So if you become injured on January 1st, 2016, and you apply on June 1st, 2016, and you get found disabled on December 1st, 2016, if you get found disabled on December 1st, they'll pay you back all the way to when you first became disabled on January 1st. They apply a 5-month offset where you don't get to accrue any back pay, but whatever your monthly payment is, on average it was $1,100. It'd be $1,100 times 7 is the back benefits for that person, and my fee would come only out of the back benefits, and it's 25% or $6,000, whichever is less, and that's just the numbers that Congress has set as a reasonable fee.
Plus expenses?
plus expenses. And typically, in a Social Security case, the only expenses that my clients have are when you order medical records, it's $5 search fee, $1 for the first 20 pages, and 10 cents a page after that. So most people have a couple $100 in medical record expenses. If it was a situation where you really needed what's called a functional capacity evaluation, where a doctor sees how much you can lift or stand and just determine the maximum exertion you can make, that would be a common expense as well. But 25% or $6,000 of the back pay, and not to count, and I don't take anything out of months going forward once you're found disabled. Yes, sir.
When discussing disability, most of us would not be on disability. Most of us would be drawing whatever the pension you're talking about.
Or the retirement.
The retirement pension, and you haven't addressed that, how that's calculated, and when and why there's an offset before FRA and so forth. Could you address that a little bit?
Right, well, retirement, I've never handled a retirement case because there's not usually any of them there. It's just based on your work history, payroll deductions. Have you met this? Usually it's around 10 years, I believe, the general rule of thumb. Have you worked 10 years paying your Social Security taxes? Then you become eligible for early retirement at age 62. And I believe right now, if you're born prior to 1948, it's like 66, or it's full retirement age. But, if you are on Social Security disability insurance benefits, not the low-income kind, but the type based on your payroll deductions, that program switches to being paid from out of the retirement trust fund once that person reaches the full retirement age. Thank you.
Can it be less than the disability pay?
Whatever your disability pay is, whatever it is at the time you turn your full retirement age, that's what the retirement trust pays as well. Does that make any sense? So if you're receiving $1,200 in disability and you turn 66, the retirement trust picks up the payment then, but it's still paying you at that $1,200, same amount. Yes, ma'am.
Using the term long-term disability insurance, but there's also a long-term insurance that we pay. Those are two different things, aren't they?
Right. Well, long-term disability insurance, like I said, is just a insurance contract you have with a private insurance company. MetLife offers this coverage for you, and you pay whatever it is, a premium out of every paycheck. And then if you're out of work for up to 3 months, you can get short-term disability, and they have some determination made by medical records that you provide whether or not you qualify for this long-term disability policy. Long-term disability insurance is a privatized insurance policy, and that's what I said is separate from Social Security. But people often call me with long-term disability questions. But it's a completely different process from the Social Security disability program.
But you can purchase long-term insurance that has nothing to do with disability, can't you?
Yeah, I'm sure there's long-term.
Long-term care, probably.
I'm not sure about what different insurance policies are on the market, but just from what I see when people are disabled, and they're calling about long-term disability, it's something completely different. It falls under, I believe, the ERISA plan, the ERISA Employment Benefits Act, and it's a completely different system. Yes.
In the case of an adult child with mental disability who's been unable to hold a job, okay, my daughter has just applied for disability,
Right. How old is she?
34.
Okay.
Unfortunately, she did it without telling me. She did it without telling me, okay. I just got a form in the mail, a very long, detailed form that I have to fill out about her. Now, since her disability is entirely mental, it's not physical.
Right.
There's really only one section in there that kind of applies to that has to do with, has she ever been laid off? Can she get along with bosses? You know, that kind of thing. Would it be advisable for me to have an attorney review that before I submit it? I'm concerned.
So you have a situation where your daughter's applying for disability and she's received a packet of questionnaires that they mailed to you asking about her conditions?
Exactly.
And this is a Social Security,
I assume so.
all right.
It's the city of, she lives in Chicago.
Okay.
I believe this is Social Security at this point.
one of the common forms that are sent to people from the Disability Determination Service is a daily, function report where they're asking you to talk about what does this person do from when they get up to when they go to sleep.
Right.
But they also send that same form to a person that the claimant says knows the most about their condition.
And that would be me.
That would be you. So you yourself wouldn't necessarily need to hire an attorney. I would just advise just fill it out the best of your abilities. But if she hired an attorney to help her out with her side of it, it would be more beneficial than you hiring someone to help you with yours. But I wouldn't recommend hiring anyone for that. And there wouldn't necessarily be.
So until she gets denied, we don't need to get somebody involved. But if she gets denied, we probably do.
Like I said, I prefer to get cases as early as I can. Not all attorneys will help out doing the initial application paperwork, but I like just to kind of see what's going on. And if she had an attorney.
We went through a guardianship thing,
Okay.
so we've been down part of this road.
If she had a attorney herself, that attorney may be able to send specific forms to doctors, things that may help her increase her likelihood of getting an initial favorable decision, which in most places is less than 30% approval rate, at that DDS level. Yes, ma'am.
On request, questionnaires may also be sent to people who are close to this person, to the applicant. Can be friends or aunts or uncles.
Sure.
People that, like you said, have observed this person. That is very helpful.
You will look at your disability, 4 or 5 years down the road to see if you're still disabled?
Yes, and I even had a case last year. Sure. Does Social Security look at cases after they approve them to see if that person still is disabled 4 or 5 years down the road, was the question. And last year I had a case where a 30-year-old gentleman was found disabled based on back issues. And the judge said in the hearing, I'm putting you up for review in 12 months. So once you start receiving Medicaid insurance on your SSI claim, go to the doctor because you're going to be up for review in 12 months. So a lot of times you see that with someone that comes in and they have no access to the free clinic because the free clinic won't see them, and they don't have cash to pay cash pay to different doctors. Sometimes judges will find them disabled with the directive, you better get treatment because we'll look and see what you've done with that access.
Social Security sends out regular periodic requests. Are you still disabled? Has your condition changed? So you have to return that right away.
Right. Any time that you are receiving disability and you come up for a review, it's an administrative process. It's not as elaborate as the initial process, but it's usually, if there is a hearing, a lot of times this determination is made inside the local office, just at a sit-down meeting, and that information is gathered that way. It's usually not as elaborate of a process for the continuing disability review. Yes, sir.
What percentage of first-time claims are turned down?
What percentage of first-time claims are turned down? I believe it's a myth when people say, well, I'm going to go in and file once and get denied and keep applying. I don't feel like that helps them out. So First-time claims, like I said, initially, all claims are 30% approval rating at the initial level, and that number goes up closer to 50 at the hearing level if they have an attorney, I believe.
Quick case. A person who had had polio as a child, who's 63 years old, who's already got 40 quarters, well more than 40 quarters earned under Social Security, but they're having problems with their particular job currently, and they are to consider filing for Social Security disability, okay? That's probably a no-brainer. However, the question is, if you do get on disability, how would it affect your ability to get on full Social Security 3 years later at the age of 66?
Okay. The question is if you receive Social Security at disability at age 62, 63, how would it affect your ability to receive full retirement benefits at 66? Generally speaking, you're going to receive the higher. If the credits you put in cause you to have a higher retirement payment than disability payment, which I don't think usually occurs. I believe usually disability is a higher paying formula. Once you're receiving whatever amount that is, you will continue to receive that amount into retirement. It's just
So if disability, for instance, was higher than what you'd receive at 66, then you continue with that amount.
with the higher amount.
However, if the reverse were to occur, then you would transfer from disability to full Social Security benefit?
I believe in that situation, like I said, generally speaking, the disability is going to be higher, but if it were to be lower than what you would qualify for at full retirement, I believe you would just voluntarily terminate your disability benefits and elect to choose retirement benefits in that situation.
Lee, thank you so much. Good to see you.